So once the case comes to the Supreme Court has to figure out whether or not it's going to be one of those 70 or 80 cases that it will hear that term. One thing that we have to keep in mind is what the justices don't do, at least according to them. And that is, they're not concerned with trying to correct all of the errors that lower court decisions lower courts may have made in rendering their decisions. At least that's what Chief Justice Fred Vinson says. But I'm not so sure. So when you want to have your case heard by the Supreme Court, you're going to start by filing a petition for certiorari, as we mentioned in the last video. You're going to file 40 copies of this, and one copy is going to go to every member of the court, and the rest will go to various law libraries around the country. In this petition, you're arguing why the Supreme Court should choose your case, why it should be one of those lucky few that are going to get a spot to be heard at the court. And to do so, you're going to talk about the factors that we'll get to in just a minute. Now, there may also at this stage be what are called amicus briefs. Sometimes people say amicus briefs. The scholars who study this are somewhat divided on which one of those is right. But this comes from the Latin term amicus curiae, which means friend of the court. These are going to be briefs from people who are not directly involved in your case, but who have an interest in the case. And they might be arguing why the Supreme Court should or should not agree to take your case. So we're not talking about the legal arguments about who should win. This is just, at this stage, all about trying to lobby for a spot on the team of cases, if you will, that the court will hear for the next term. So these petitions are distributed to each of the justices' chambers for review, and 7 of the 9 justices use something called the cert pool to take the first pass at reviewing these. So Justice Sam Alito and Justice Neil Gorsuch do not participate in this, but the other 7 use their law clerks. Each associate justice has 3 law clerks, and the Chief Justice has 4. So those 7 justices have a total of 22 clerks, and they'll divide all of those petitions, so 7, 8, 9,000 of them a year, equally amongst themselves, and they'll write up basically like a short summary, a cert pool memo that will describe what the issue in the case is, what the lower court has done, and make a preliminary recommendation on whether or not this merits a closer look by the justices. So then those cert pool memos are distributed to the justices, and any justice can take a case and add it to what's called the discuss list for discussion at their Friday meetings called conferences. When it's brought up then, each case will be discussed by each of the justices in order of seniority. So it'll start with the Chief Justice and end with the most junior Associate Justice, which in this case is actually Kavanaugh, not Gorsuch, because Kavanaugh is the most recent addition. After each justice speaks, then there will be a vote on whether or not to agree to hear this case. And we would call this a vote to grant cert. It takes 4 votes to grant cert, and once those 4 votes are received, then the parties to the case are notified that their case has been granted cert, and it will proceed on to the merit stage. So this is just a fun illustration of this idea that it requires 4 justices in order to hear a case. But why would they? What would compel them to agree to hear a case? One of the biggest reasons has to do with that map that we saw in the earlier video. If different courts around the country have heard the same issue, but have come to a different decision, then we have different application of the same law in different parts of the country. And that's bad, right? That's a bad thing if you don't know what the law is, depending on which circuit you're in. So that's the single most common reason that the justices say persuades them to agree to hear a case. It is to resolve differences among the circuit courts of appeals. The next most common reason is that the case presents a constitutional issue. So when cases have to do with something in the Constitution, something about one of the powers delegated to the branches or something in the Bill of Rights, that makes it more likely that the court will hear the case as opposed to something that's dealing with state or statutory law. Another reason is if it involves a lot of people. So in this picture, we see lots of people. When a case impacts large swaths of the American public, the court sees it as being more important. Whereas if the case only involves a few people, then it's probably not the best use of the court's time to take up and render a decision in that case. Another reason that the court might agree to hear a case is different than what you might expect. So a lot of people think that the court would be more likely to hear a case if it's a super controversial issue. But in fact, the Supreme Court doesn't like to take controversial issues. And to think about why, you only have to think about who enforces the decisions of the Supreme Court. It's not the Supreme Court. It's generally the executive branch headed by the president. So if the Supreme Court takes a controversial decision and the president doesn't agree with it, the Supreme Court has to hope that the president will go ahead and allow the executive branch to enforce it above his, or maybe someday her, objections. So this is why we get something that judicial scholars call percolation. The idea of percolation is that it takes a little time for stuff to make its way through the court system. We don't want to have the Supreme Court take up an issue that's relatively new on the scene. We want, as a Supreme Court justice, you would want lots of other state courts and circuit courts of appeals to have a crack at solving this legal issue before you take it up, because you're going to be the final word on it. So you want to hear what lots of other smart people think about this issue before you have to make a decision. Another reason that the court might agree to hear a case is that they feel like a lower court has misapplied the law or perhaps ignored a previous decision by the Supreme Court. They want to make sure that their legacy and their decisions are honored by the other courts of the federal court system. And so if they see a lower court is misapplying a legal standard that they've set, or if they feel like the lower court has misapplied the Constitution, because they see themselves as the protector of the Constitution, they're more likely to take that case. Now, remember back just a few minutes ago, I was talking about how sometimes we see amicus briefs at this stage where the court is trying to decide whether or not they want to take this case. When there is an amicus brief at the cert stage, so not when we're talking about who should win, but just when we're talking about whether or not the court should agree to hear the case, that signals to the court that this is an important issue. Because remember, less than 1% of the cases are going to get taken by the Supreme Court that ask for review. And so when an organization or a person or a group of people has agreed to lay out the costs to pay really, really well-paid attorneys, the fees that it would take to write an amicus brief, it sends a powerful signal to the court that even though there's less than a 1% chance that they will take this case, the people were willing to fork over that money to do it anyway. So there's one other reason that the court might agree to hear a case, but we're going to talk about that after we talk about how the court goes about making a decision, which we'll do in the next video.